Let me share my screen. So this is the scope of module 3, where we'll start. So in module 3, it is basically related to information to the police, their powers to investigate, and inquiry proceedings. So let's start chapter 1, which is initiation of the investigation proceedings, section 173 to 178, and evidentiary value of FIR and statements made to the police officer. Okay. So let's start with section 173. It used to be 156 in CRPC. So the section, in the plain reading of the section, says every information relating to the commission of cognizable offense, irrespective of the area where the offense is committed, may be given orally or by electronic communication. This is an addition to an officer in charge of a police station. And if given, now it can be given orally and electronically both. So now both the options should be evaluated. So orally, it shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing, as aforesaid, shall be signed by the person given. So if it is given orally, it has to be reduced into writing. Number 2 is by electronic communication. So it shall be taken on record by him on being signed within 3 days by the person giving it. And the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may by rules prescribe in this behalf. Now, provided that if the information is given by a woman against whom an offense under so and so sections, so sexually related offenses, uh, is alleged to have been committed or attempted, then such information shall be recorded by women police officer or any women police officer, provided further that in the event that the person against whom an offense under so and so sections mentioned earlier is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be recorded by a police officer at the residence of the person seeking to report such offences or at a convenient place of such person's choice in the presence of an interpreter or a special educator, as the case may be. And B, the recording of such information shall be videographed, and the police officer shall get the statement of the person recorded by the magistrate under clause A of subsection 6 of 183 as soon as possible. This is part 1. Part 2 talks about a copy of information as recorded under subsection 1 shall be given forthwith free of cost to the informant or the victim. 3. Without prejudice to the provisions contained in section 175 on receipt of information relating to the commission of any cognizable offences which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with the prior permission from the officer, not below the rank of a DSP of police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. Proceed with investigation when there exists a prima facie case. Point 4 says, any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned who, if satisfied that such information discloses the commissions of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him, in the manner provided by this Sanghita, and such officer shall have all the powers of an officer in charge of a police station in relation to that offence, failing which such aggrieved person may make an application to the magistrate. Now, this is a very wide section, and it has to be that way because this is the first very basic baseline, not basic, the very first baseline for the procedure of recording of a complaint. So it has to look into all the perspectives. Start to end, if we see, we talk here about the oral or electronic communication. We have special provisions around the sexual offenses or the offenses related to any kind of grievous hurt, acid, injury, etc., etc. And then it talks about, again, if orally or electronically, whatever has happened, but if such a issue has such a complainant is a woman and such an offense has happened with that woman, then that has to be recorded by a lady police officer. In case of somebody who is not mentally much capable, in that case, that disabled person has to be his statement or her statement to be recorded mostly in a at their residence or the place of choice, and then probably an interpreter or a special educator might be required to understand the communication. And in that case, the uh, recording should happen. The videography should happen during the recording of the statement. And the person should be immediately taken to as soon as possible to the magistrate to record his or her statement under section 183 6A. Second part deals about when such a complaint has happened and the complaint has digitally or orally or in written, whatever it has come to the police officer, the copy of the information which is recorded has to be given free of cost to the victim and or the informant as well. So this is something at the end which talks about also in case it is not being recorded. So let's see one by one. So reporting and information is the key subject area of section 173. 173 is primarily talking about reporting information. So subsection 1 is all about how to report the information, which says information regarding a cognizable offense. So this is all about cognizable offense. Can be reported either orally or via electronic communication. So these are the modes which are possible, no matter where the offense occurred. So offense has happened wherever, you can report it to the police officer. Now, in case of oral reporting, the information has to be diligently transcribed by the officer onto the paper. And for verification, it has to be signed by the informant. The person who is an informant, he has to come and sign. Now, the person who is informant could be, as per law, could be somebody who is actually somebody who is connected with the matter, or somebody who is just wanting to report that matter on behalf of somebody. Electronic reporting, where electronically communication is happening, then it has to be signed by the informant within 3 days coming to the police station, and such information has to be recorded in a register set by the state rules. Special provisions for women and disabled person, we saw this has to be done by a woman, and if the victim is disabled, the police must record information at the victim's choice of place or house and provide necessary assistance, and a videography has to happen, and to ensure the magistrate records the statement promptly and as soon as possible. Because in case of in such scenarios, it is very, very important to record the things as soon as possible. There's quite a chance we might lose the evidences or the person might lose the memory of the situation very soon. Then subsection 2 of 173 is talking about provisions of the information. So basically a copy of the recorded information has to be provided, provision immediately and free of cost to the informant or the victim whomsoever, so that the person transparently is aware of what exactly is the information which is recorded, and the person understands what has been recorded for him. Subsection 3 talks about preliminary inquiry for certain offenses. So there are some offenses where a preliminary inquiry is possible. So for offense punishable with imprisonment ranging from 3 to 7 years, the officer in charge may, with prior permission from an officer not below the rank of a DSP. So in city sense, we say not below the rank of an ACP. Conduct a preliminary inquiry to determine if there is a prima facie case within 14 days. And in prima facie case, if it is established, the police officer should proceed in full investigation into the matter. And this step ensures that the police resources are utilized effectively and the case are screened out at every stage. So every stage the case is being screened out. So we have screened out that it is what kind of offense, up to what year of imprisonment it is. Does it looks prima facie a problem or it is not? Depending upon that, a permission has to be obtained and investigation can happen either prior to recording it, 14 days before, and or in case the prima facie case is established, should full be the full investigation into the matter after recording the complaint. So in the part, the Supreme Court has recently come back with a judgment where it has clarified that it is good to have as per the new provision, have a preliminary inquiry so that a proper complaint could be recorded in cases where it is required. Now, addressing refusal to record information. Now, when we talk about the complaints will be recorded, there is quite a chance it might be refused also. So if an officer refused to record information as described in the subsection 1, the aggrieved party may send the details to the information to the superintendent of the police. So in city sense, you might send it to the DCP through the ACP or to the ACP also, but directly it has to go to probably mostly as per the provision, it has to go to the DCP, which is the rank of the superintendent of police in the city ranks. Supervisory oversight is also given here so that at every level, a DSP, which is ACP, or a SP, which is a DCP, at that level, the supervisory oversight is also there to the police officer, and there is a recourse to the magistrate if the complaint is not acted upon. So if it is not acted upon, the person has a right to escalate the matter to a magistrate also. So this is about 173, which is the base first section in the initiation of investigation. Then we move to section 174. So the headline, the title of the section 174 is Information as to non-cognizable cases and investigation of such cases. So there are two types of crimes which are listed in Bharatiya Nyaya Sanhita, or it was in IPC earlier, were cognizable, non-cognizable. So cognizable, where police officer has a direct right to arrest, and non-cognizable, they cannot arrest without a warrant. So no non-cognizable offences is very commonly called in police terms in police stations as the NC. And the cognizable offence reporting at section 173 is nothing but the FIR. But the right way of addressing 174, which is NC, is a FIR in a non-cognizable offence. So basically both are first information report, but the first one is FIR in cognizable offence, and the NC is also actually an FIR, which is called FIR in non-cognizable offence. If you read the non-cognizable offence letter also, which is given to you by the police officer when you file an NC, you see on the top, it is written FIR in a non-cognizable offence. So both are FIR, but one is in cognizable, one is a non-cognizable offence. So section 174 reading is, when information is given to an officer in charge of a police station of the commission within the limits of such station of a non-cognizable offence within the limit of the station, he shall enter or cause to be entered the substance of the information in a book to be kept by such officer in such form as the state government may be by rule prescribe in this behalf. Refer the and number 1, refer the information to the magistrate. Forward the daily report of all such cases fortnightly to the magistrate. No police officer shall investigate a non-cognizable offence case without the order of a magistrate having power to try such case or commit the case for trial. And any police officer receiving such order may exercise the same powers in respect of the investigation except the power to arrest without warrant as an officer in charge of a police station may exercise in a cognizable offence. And number 4, where a case relates to 2 or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. So what does it say 174? The very key difference what we hear from the plain reading of 173 and 174 is the 173 says a crime which has happened anywhere while 174 says a crime which has happened in the jurisdiction of the police station. This is the first basic difference. So reporting non-cognizable offense is something which is we talk about in section 174, and subsection 1 talks about it sets for the procedure for handling the reports of a non-cognizable offense, which are generally less serious offenses. That's why they are non-cognizable offenses in the first place, and that do not require an immediate police action or arrest. These are non-cognizable. The legislature has marked them as non-cognizable because these are the offenses where no immediate police attention is required, and that is why they are categorized that way. Now, information recording. So, in case of a non-cognizable offense, how the information has to be recorded, which is 174, section 1 says that when information about such an offense is received, the officer in charge must document the substance of this information in a designated book. So, it has to go a designated book to be reported, following the format prescribed by the state government. Now, state government generally gives a format of the information which is required, while the specific format on how it will be printed, the NC on a paper, is mostly depending upon zone to zone, police station to police station. Also, it might look different also, little bit here and there. So there is no fixed exact printing look which is same for all the police stations NC forms, but it might look a little bit different here and there. But what is controlled by the state is the information which has to be recorded and the procedure which has to be followed. So the officer in charge must document the substance of the information in a designated book following in a format prescribed by the state government. This ensures systematic record keeping and accountability. So there is a record which is created. So tomorrow, if a record of an NC has to be found through the serial number. Nowadays, as every NC is also lodged online as FIR. So with the serial number or the date and the name reference, it could found in the digital books of the police department. Now, referral to the magistrate is a third important point, which is part of subsection 1, which says the informant is referred to the relevant magistrate. In getting the legal recourse can be sought through the formal judicial channels rather than the direct police action. So, if required, it goes to the relevant magistrate. Not every NC complaint goes to the magistrate for its pursual. It goes to the magistrate in case if the police believes they highlight that to the magistrate. Otherwise, it goes in a routine reporting to the magistrate on every 15 days, which is not highlighted to the magistrate and no action is required. And that is the fortnightly report with a daily diary report, which is collected, combined for a 15-day time period, and it is submitted to the magistrate office. So, submission to the magistrate office every 15 days does not mean magistrate is going to read all those 15 days, all those NC papers. No, it is only the ones which is highlighted by the police is brought to the notice to the magistrate. Otherwise, it is just recorded for the sake of recording and keeping with the magistrate's office as a report of what all types of complaint has been, NC complaints has been registered. Now, there is a restriction. If we read the section clearly, it says there is a clearly says a restriction on investigation. So there is a strict rule about police cannot jump into an investigation into the non-cognizable cases. So they are strictly prohibited from investigation into a non-cognizable case without obtaining prior authorization from a magistrate. So if somebody goes ahead and files a non-cognizable offense against you, say for example 5064, 504, etc. in the IPC. So in those cases, if a police officer asks you to come there and ask you a few questions or sends a notice to you or gives a letter to you, a warning letter, etc., that is fine. But if they proceed beyond that and they say they want to investigate, then you have to go back and check if there is a magisterial order received, because there is a strict prohibition and nobody can harass you for that subject. So it has to come from a magistrate who possesses the authority to try the case or to commit the case for trial. For that, on every e-courts, Maharashtra or any state e-courts website or any court register earlier, now it is easier, it's in the e-court website, that every e-court website of every state in every district has a list of the magistrates who are connected with the police station. So the magistrate who possesses the authority is on a roster basis already listed and published online nowadays. So this prevent unwarranted police action because the police on the ground might go ahead conveniently into getting into investigation and deeper into it when it is a clearly a case of a non-cognizable offense. And to stop that, such kind of attention and the right places police could use their attention, the judiciary's overseeing investigation initiation is added into this. Now, powers of a police officer is also added in subsection 3, where it says a police officer receives an order from a magistrate to investigate a non-cognizable offense, then they are granted powers similar to those of an officer in charge of a police station. So this is nothing new. Every police officer who has powers to investigate any matter has powers of the officer in charge of the police station, because they replicate the police officer in charge of that police station all the time, except from the duties of administration, etc. So delegation power, etc. So, with the notable exception that they lack the authority to arrest individuals without a warrant. So, even when a magistrate asks somebody that, oh, in some matter, sorry, that investigation can happen, and in that case, the police officer who is doing it is given a power similar to investigation of the officer in charge, which is a legal way of saying they have power of a police from that police station to investigate in a cognizable offense. Why this is said? Because investigation is always automatic through for the cognizable offenses. The moment the switch is switched on for the investigation, automatically it comes as if he is investigating in any cognizable offense. That's what it means here. Now, there is a notable exception that they lack the authority to arrest. One can say I've got power to investigate as in case of a cognizable offense. No, I have only powers up to investigate, but I don't have power like arresting what we have in the cognizable offenses. So, still in non-cognizable offenses, even if an instruction is received from the magistrate to ensure that the investigation can happen, the police officer is empowered with the right powers to go ahead and investigate only, not to arrest until and unless the magistrate further issues in due course any warrant for arrest. This means that while police can conduct the investigation and gather evidences, they must still adhere to strict procedural limitation regarding arrest. So they cannot go for an arrest at that point of time. And in terms of the mixed offenses, subsection 4 talks about two or more offenses, and at least one of those offenses cognizable. So, for example, somebody is charged with in an FIR, the 173 FIR, into some cognizable offenses, and then there are also some non-cognizable offenses which have also been committed in that case. It is not that you will write a 173 and a 174 two different FIRs. The police will write only one 173 FIR, and it will include all the non-cognizable offenses also there in the same FIR, and it will be treated at par with all the cognizable offenses and have the power automatically delegated to the police officer in those cases also as a cognizable offense and including the power of arrest. So as they could arrest in a cognizable offense, they can still arrest in case there are cognizable offenses which are accompanying together with the other sets of non-cognizable offenses in the same set of incident. So this provision and acknowledge the practical realities of the legal situation. So this is a very good practical situation by bridging a gap where what happens, both happens. So ensure that the serious offenses are addressed. So in case a serious offense, so cognizable offenses are always serious and non-cognizable offenses are non-serious offenses. So in case non-cognizable, we are giving a liberty to not get arrested, not get investigated until and unless there is a supervision and order from the court. But when in case there is a higher order of crime which has happened, which is cognizable, automatically everything else comes under the umbrella of that particular offense, which is a cognizable offense, and that highest order of offense which has happened in that particular incident. When I say highest, it doesn't mean the multiple uh, cognizable offenses. I mean between the cognizable non-cognizable offenses. So in that case, the police has immediate given liberty to take indication from the cognizable offense side and continue with the investigation without waiting for any magistrate's order to initiate any investigation. So this practical implications of this particular section is basically it is given in efficiency in handling cases. It, it gives a clear understanding on what should not be done in a non-cognizable offense, and it protects the right of the people while it encourages an accountability also to the police officer to uphold the rules and processes, while at the same time it empowers the police officers also in case a mix of situation is happening and in the same event, in the same uh, situation, the cognizable, non-cognizable both has happened, then the investigation should happen automatically as the cognizable offenses for everything whatever is recorded in that section 173 FIR, and it will be treated as if fully everything is cognizable. Moving to section 175 now, which is the title says police officers power to investigate cognizable offenses. Now the reports are the FIRs are drawn. Now the power to investigate in a cognizable case is the title for section 175. I have recorded under 173. Now I'll go ahead and investigate. So the plain reading of the section, what it says is, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case with a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provision of chapter 14, provided that considering the nature and gravity of the offense, the superintendent of police may require the DSP to investigate the case. Point 2 says no proceedings of a police officer in any such case shall at any stage be called in question on the grounds that the case was one which such officer was not empowered under this section to investigate. Subsection 3 says any magistrate empowered under section 210 may, after considering the application supported by an affidavit made under subsection 4 of the section 173, and after making such inquiry as he thinks necessary and submission made in his regard by the police officer. So 173 inquiries we talked about that, which is where the police officer, in case of a prima facie or something which is not clearly a prima facie case, how they proceed, made in this regard by the police officer, order such an investigation as above mentioned. Subclause 4 says any magistrate empowered under section 210 may, upon receiving a complaint against a public servant arising in course of the discharge of his official duty, order investigation subject to receiving a report containing facts and circumstances of the incident from the officer superior to him, and after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. So we have spoken about it a day or two back also, where we talked about why a public servant is basically allowed to put an assertion on whatever is being alleged against them, and also seeking a report from their senior officer. And when we talked about magistrate empowered under section 210, we're talking about where a public servant has made a legal mistake by, and that's how it has to be then treated. So let's read up plain the section 210 once, just so that we can then summarize after that. So cognizance of an offense to the magistrate is something which we talked about in the particular section. I think we have gone through it earlier as well, where the subject to the provision, how the magistrate or the first class or any magistrate of the second class is empowered to take a cognizance upon receiving complaint from a fact from a person, police, or a person other than a police officer upon his own knowledge. So we studied this, I think, in a previous day, in a previous session. So what does this section talks about is basically, it talks about the authority to investigate a cognizable case. So how a cognizable case could be investigated, and that is why what is the subject of this particular uh, section. So section 175 is basically nothing but empowering any officer in charge of a police station to initiate an investigation into a cognizable offense without requiring prior approval from a magistrate. So that is a key of 175. This particular power is nothing but an autonomy given to the police officer to act quickly. Because in case of cognizable offenses, the time is also of a great essence. So it allows them to act quickly in a response to a serious allegation and which demands an immediate attention. Now, it also says the police officer can only investigate cases that a court with jurisdiction in that area has the power to inquire into or try according to the provisions laid in Chapter 14. Chapter 14 is nothing but how the criminal courts act, basically in the inquiries, etc., etc., and what are their jurisdictions. So the police officer can only investigate cases that a court with that jurisdiction in that area has a power to inquire into. And the superintendent's oversight is also required as per subsection 1, where it says the provision includes a clause indicating that if the nature and gravity of the offense warrant it, the superintendent of the police can delegate the investigation to a deputy superintendent of the police, reflecting a structured approach to managing serious cases. In case a serious case where a supervision is required and the superintendent of the police, which is a DCP in this R context, if the police officer at that rank is sufficiently satisfied that a supervision is required from a senior officer, they can ask a DSP in the rural context or a ACP in terms of a commissionerate-based police system. The subsection 2 talks about immunity from challenge. Now, if a police officer has been given absolute autonomy on going ahead and start an investigation, the person also should be protected as per the principles, and where we talked about the government subjects uh, are protected at up to certain extent to ensure they are able to work efficiently. So there is an immunity from the challenge in subsection 2, which it is mentioned. Now, this section establishes that the actions taken by the police officer in investigating these cases cannot be challenged on the ground that the officer lacked the authority to investigate under this section. So this has double meaning. One meaning is the officer, when they are doing any action in investigation, these cases, they cannot be challenged on the ground that the officer lacked the authority to investigate. So they have power given to investigate. But then there is also a limiting factor which is also inserted in this particular section, is why officers in investigating these cases, so they have to do something which is reasonable and correct only for the purpose of investigation of the cases, because this power only gives a power to investigate. They don't have power beyond that. So they can do investigation depending upon that, and the legal protection help ensure that the investigation is proceed without undue obstruction and second guessing of police authority during the investigation process. So they are not, sticking or stucking into a situation where they are doing guesswork. And for that, it is very much desired and it is practically understood that the police officers would need to dig into some things. They need to go ahead and investigate. They have to look into certain facts and they have to go ahead to speak with certain people, get into certain places, have to, conduct certain searches, etc., which is discussed further. So all those things, the police officer is empowered to, in fact, even making a person's attendance compulsory. Now, in this case, subsection 3 also adds a magistrate's authority. So, any magistrate who is empowered under section 210 can order an investigation in a cognizable case after reviewing an application supported by an affidavit. And the magistrate has the discretion to make such inquiries as they deem necessary, giving them a supervisory role over police investigation. Now, we talked about two levels of supervisory engagement in this section. So, one level is definitely by the supervisory organization of the police department, which is the DCP and the ACP. But in this case, there is also a possibility of magistrate supervision also over the overall police investigation also. And if they want to do that, they can also do that. And they can order an investigation in a cognizable case after reviewing an application supported by an affidavit and the magistrate has the discretion to make such inquiries. So they can also make an inquiry, and which is supported by an affidavit. If somebody files an affidavit in that regard and the magistrate believes it, that under their discretion, if they want to make such inquiries, they can also make supervisory inquiries to ensure things are running fine as they should be. And this provision creates a check and balance within the judicial process over the police also. So there is an intervention by the magistrate in sensitive cases. If that is has to be done, that also could be done with the aid of this particular section. Subsection 4 then talks about provision 2 for complaints against public servants. So we have been till now every day, whenever we are talking about the public servant, we know they have got a certain level of immunity, because once if it is understood if they are under the public services, they are also under public scrutiny, and there might be a lot of backlash and pushback on various policy and work related thing what they will do. And that is the reason the police, etc., and even any other public servant is given some kind of immunity. And in it's no exception than any other sections what we have read. The inquiry, the magistrate can order an investigation into such complaint but only after that person's assertions regarding the context of the alleged offense. What does he responses on that? And also a report from the superior officer about the circumstances of the incident, sorry. So this required an additional oversight which is added for the public servant. So what does this section 175 overall is doing is, it's an effective, efficient law enforcement which is given to the police officer to be autonomous and do investigation with some immunity as well onto the subject of investigation in double quotes. And legal protection for the investigative action is provided, and accountability to the public officials is added as in any other such sections, and that is how the protection is also given to them. Now, the power has been discussed in terms of section 175 about how the police officer has power to investigate a cognizable case. So we had registered a cognizable case under 173. Now we discuss what is my power as a police officer to investigate the cognizable case. Now we talk in section 176. See, it's very logically the sections are placed. So 176 now talks about, I have the power, I have the complaint in hand, then what is the procedure for investigation? With the power in hand, how do I proceed? What is the procedure of investigation? So section, by the plain reading first from the section, subsection 1 says, if from information received or otherwise an officer in charge of a police station has reasons to suspect the commission of an offense which is empowered under section 175 to investigate. Now, power is delivered from 175. If the person has that power, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person, or shall depute one of his subordinate officers not being below such rank as the state government may, by general or special order, prescribe in this behalf to proceed to the spot to investigate the facts and circumstances of the case, and if necessary to take measures for the discovery and arrest of the offender. So normally every state government gives a permission to various ranks on what level of investigation they could do. And normally the lower ranks are not allowed to go ahead for the start of the investigation, uh, to go to the spot alone and uh, bring in all those investigation initiation reports, etc., and make recordings starting the investigation, etc. So different levels of officers are given, different levels of authorization, and depending upon various specialized crimes also it is given that way. For example, in general, in a police station, a person who is at the rank of Havildar or above is, or ASI or above, is allowed to get into a murder investigation also, but now nobody below that. But in general, to bring in efficiency and bring in far more superior results, it is normally not given below the rank of a sub-inspector. So it is a discretion of the police officer sitting in the police station and the bandwidth and the availability of the officer. He may decide who will go. That is what is decided, mentioned in subsection 1. So subsection 1A then says, when information as to commission of any such offense is given against any person by name, so a name is given that such commission of the offense has done by so and so person, and the case is not a serious nature. The officer in charge of a police station need not proceed in person or depute a subordinate officer to make an investigation on the spot. It is then not required. If a complaint has been brought forward by the name and the case is not serious. Now, why the word name has been added in the subsection 176(1)(a) is that is giving a far more certainty to the police officer. If somebody has to do an investigation in all the cases, it is okay if the bandwidth permits in all the cognizable offenses. But in such a case where a police officer is very well aware by the name, the identity of the person. So basically, when somebody gets a name, they get all the identity around that person. So when they know by the name who has done that, and they know the background of the person, they have done a small investigation through the people around them or through the other police officers. And in case it is not serious nature, it gives an assurance to the police officer that things are fine and I know who has done. And tomorrow, if it goes beyond, I know who has done it earlier. So they need not send a police officer immediately to investigate on the spot. It can be done with ease and flex. While B says, if it appears to the officer in charge of police station that there is no sufficient ground for entering on an investigation, he shall not investigate the case, provided further that in relation to an offense of rape, the recording of a statement of the victim shall be conducted at the residence of the victim or in the place of her choice, and as far as practicable by a woman of police officer in the presence of her parents or guardian or near relatives or social worker of the locality. And such statement may also be recorded through any audio, video, electronic means, including mobile phones. Now, it is a matter where the section 176(1)(b) talks about that if there is no sufficient ground they feel, then the officer in charge has a power to go ahead and decide to not investigate the case. But in offenses of rape, these are the special provisions which are given. Subsection 2 says in each of the cases mentioned in clause A and B. So what is A? A name is given, not serious nature. B, it is not a case where it is sufficient. The crime is not sufficient enough to be considered serious. So in each of the cases mentioned in clause A and B of the first proviso to subsection 1, the officer in charge of the police station shall state in his report the reason for not fully complying with the requirement. So if the police officer in case of non-cognizable offense is not allowed to investigate, in case of cognizable offense, they have to report clearly why they have not acted in case of a cognizable offense. So there is again a check and control in that regard. They just cannot go back in a cognizable offense and go ahead and decide not to investigate. So the police station in charge has to take this responsibility to report the reason for not fully complying with the requirements of that subsection by him. And towards the daily diary report fortnightly to the magistrate, they have to forward it. In the case, if the case mentioned in the clause B of the said proviso, the officer shall also forthwithly notify the informant, if any in such manner as may be prescribed by rules made by the state government. The subsection 3 says, on receipt of every information relating to commission of an offense which is made punishable for 7 years or more, so a harsher crime, the officer in charge of a police station shall, from such date as may be notified within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offense. And also cause videography of the process on mobile phone or any other electronic device, provided that one forensic facility is not available in respect of any such offense. The state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. So they can use any other state or any other district also. So detailed explanation of section 176 how to do. So investigation initiation. So this section is all about initiating the investigation and the procedures around that. So it outlines the procedure for the police officer to initiate the investigation with the power we have received in section 175. That is based on the information received. So of course, every investigation has to be initiated based on the information received. What kind of information, where it happened, how many people or single person is or involved, whatever. So when an officer in charge of a police station suspects that an offense has been committed, they must act swiftly. The section says first you go and act swiftly and then report to the magistrate, who has the authority to take cognizance of such offenses. Then second part says, the subsection 1 says the responsibility of the officer. The officer will act swiftly, report the matter to a magistrate, and who has authority to take a cognizance of such offense, and they will start the investigation. But the responsibility is upon the police officer is, as imparted by subsection 1, is upon suspicion of a suspicious of a cognizable offense, the officer in charge must report the matter to the appropriate magistrate, but must then proceed to the scene of the crime also in person or designate a subordinate officer. So every police station is represented by the police officer in charge, and everybody is a delegated officer for him or her, whom he or she sends to those investigations. So they have to proceed, or the delegated officer has to proceed to the scene of the crime in person or designate a subordinate officer, but it has to meet the rank requirements for that particular investigation as per the state government GRs, and to investigate the fact and gather evidence. The prima facie, whatever fact is seen and the evidences are gathered, that happened at that point of time. Sealing and storing of the evidences happened at that point of time. Forensic also is involved at that very same time. So they have to take all the measures also to arrest the offender also in case that is necessary or possible. Then, in spite of this, there are two exceptions given. So they have got powers to, they have to go out, inform the magistrate, they have to go to proceed to the site, they have to start the investigation, blah, blah, blah. But then there are two exceptions given. One is in case of a minor case, which is the person is known by the name. So very certainly the police officer knows whom we are talking about. And then it's a very minor case. So officer may choose not to investigate the particular matter. Or the second exception is there is a lack of ground for investigation. If the officer finds insufficient ground to justify the investigation, then also they can come back and call it off and they will not investigate. But in both the cases, they have to file a clear report detail about why it is not done. So special considerations for the rape case is also mentioned in this section, where in case of such allegations, the provisions are made to ensure that the statement is made in a safe environment, either at her home or at the residence of somebody else, any place where the woman feels safer, but only through a lady police officer, ensuring number one, sensitivity, and number two, respect to the privacy of the lady. The process can also be documented through audio and video, means it maintains a record of the victim's testimony, enhancing credibility and evidence collection. But the section is written this through it may the process can also be documented. So it is not mandating it, but it is the states amendments, etc., which might reinforce it in some states or all of the states. But at the moment, it says it can also be. Reporting any documentation. Sorry, reporting and documentation. So subsection 2 talks about officers not complying with the requirement, means they are not proceeding with the investigation because of some of the exceptions, etc., must provide a reason in their report for such non-compliance, reinforcing accountability. So they have to comply why they have not acted in a cognizable offense, and it has to be clearly documented, verifiable. They must also submit a daily diary report for all the cases to the magistrate every 2 weeks, ensuring the ongoing tracking of the action taken and the status of various cases. This requirement promotes accountability. So basically, this creates an accountability when the police department is in question. Forensic evidence is something which is covered in the subsection 3 of this particular section. So forensic evidence collection says that upon receiving information about such an offense, punishable by imprisonment of 7 years or more. So it's a big crime category. So the officer in charge must ensure a forensic expert is dispatched to the crime scene to collect the relevant forensic evidence, because they will only know how to appreciate the right kind of evidences and how to store them. So this step is essential for building a solid evidentiary base for the prosecution. Videography of the evidence gathering is also something which can be done, and some kind of alternate arrangements could also be done in case there is no forensic team available locally. It could be imported from some other districts or states as well. So it is a very swift action which is brought into through this section. It's a protection for a vulnerable victim also, and efficiently documentation and accountability. So in summary, this is a very essential for understanding the procedure what is done by the police officer. Now let's move to section 177, which is reports how to submit. So reports how submitted. Now the section plain reading says, every report which is sent to a magistrate under section 176 shall, if the state government so directs, be submitted through such superior officer of police as the state government by general or special order appoint in that behalf. And such superior officer may give such instructions to the officer in charge of the police station as he thinks fit, and shall, after recording such instruction on such report, transmit the same without delay to the magistrate. So that is how the reports which are created under 176 are forwarded further to the magistrate. So this is talking about a submission of the report 177 to a magistrate. And this section also ensures that the communication between the police officials and the judiciary is standardized and that there is a clear chain of command in the reporting process. So we talked about every 15 days or 10 days or 7 days, the police has to keep sending the report. And that is where it has to go via a senior superior officer. Requirement of a submission through a superior officer, that's why is a something which is mandated under this section. And it has been submitted through a designated superior officer, which is legally designated by the process and by the state GR. So this provides an oversight, which is much necessary. Now, instructions from the superior officer is also added in this section, which says the designated superior officer has the authority to provide instruction to the officer in charge of the police station regarding the content or handling of the reports. This can include directives on further investigation, clarification of details, or other administrative guidance necessary for the same. And then subsection 2 talks about the recording of the statement, where it says the superior officer must record any instruction given directly on the report before the transmitting it to the magistrate. The superior's oversight is also there. Now, timelines are also drawn where subsection says that the superior officer must transmit the report without delay. It doesn't give a specific number of days, but it has to be without delay. When we don't mention a specific time limit in any of the procedural laws, it means a reasonable time, because it is assessed from the other side, which means if there is a allegation of a delay for any kind of indiscipline or foul play by the police, it could be asked, and the person has to probably explain the senior officer why there was a delay and why this is considered not to be a delay. So this is very critical wording from the section, which is a control on the police officer's work also, that they work in the timely manner, emphasizing the importance of timely communication in the legal process. So that is what is about section 177. And final one is section 178, which is power to hold investigation on preliminary inquiry, which is a very hot topic currently in the arena of the Indian judiciary and in the police department, which is does the police has a power to investigation in preliminary or doing a preliminary inquiry in all the cases, specific cases, and whatsoever. So let's talk about 178. So the section says the magistrate, on receiving a report under 176, may direct an investigation, or if he thinks fit, at once proceed or depute any magistrate subordinate to him to proceed to hold a preliminary inquiry into, or otherwise to dispose of the case in the manner provided in this Sanghita. So all the sections from 177 to 77, 73 to 77 gives the police a power to discard, do a preliminary investigation, and then either proceed or discard, and then uh, disclose their powers and the procedures, which is a power given to the police in case of holding a preliminary inquiry to be able to discard or continue with the registering of a case. So that is something which is upholded by the Supreme Court recently. Now this part talks about the power to hold investigation on preliminary inquiry. So which is an authority of the magistrate. So section 178 grants the magistrate the authority to decide how to proceed after receiving a report submitted under 176. Now with all the preliminary investigation, etc., what the police has done, depending upon the prima facie matter or non-prima facie matter, etc., etc., it's an procedure which the police can definitely go with, the Supreme Court says. And 178 grants the magistrate the authority to decide how to proceed after receiving a report. So before receiving the report, police might do a pre-investigation to further develop their case or further discard the case. But then when it is done, everything is done, and the report is generated, the magistrate has the authority to decide how to proceed after receiving a report under 176. So the report submitted on 176 is nothing but the charge sheet concerning the cognizable offense. So the magistrate has the discretion to determine the most appropriate action based on the specifics of the case. This is what is called as discharging the matter. So 178 is talking about the magistrate has to power to discharge the accused of all the issues, all the sections, all the crimes which are listed in that particular FIR through the police report, if the magistrate finds it. So upon receiving the report, the magistrate has several options. Either they can proceed directly and discharge it. So they can appropriate, they can proceed directly with the inquiry without further delay, and they can expedite the proceeding and close it. Or for some reason, if the magistrate believes there is a foul play or there is a deficiency, etc., or some technical issues, they can direct that a further investigation be conducted to find any necessary to gather information in the case surrounding the subject of the case. And they can also do a deputation to a subordinate magistrate also, that the magistrate can delegate the task to a subordinate magistrate, and the delegation is crucial for managing caseload also and effectively ensuring the case receives the proper attention. So in case the magistrate receives it, depending upon what's in the charge sheet, they can go back and apply their mind, they can proceed directly and discharge, or they can direct an investigation further to conduct if they believe right set of informations have not brought in, the right kind of inquiry has not happened, and they want a further investigation to ensure somebody doesn't go scot-free just because the charge sheet says so. Or they can do a deputation of a subordinate magistrate to run the show at the lower level. So it also talks about the preliminary inquiry ward, which is which is an inquiry ordered at the very start, and it involves gathering additional information, evidence to ascertain there is a sufficient ground. So preliminary inquiry is done to ensuring there is a ground to proceed. And once the disposing of the case, if the case has to be disposed, if the magistrate feels it appropriate, the as per the procedure, they can also discharge it. So it gives a judicial efficiency, it's a judicial control and flexibility also, where if there is everything fine, no need to go through all the processes, A, B, C, D, E, F, G, H, and keep working on that particular matter if it is not something which is going to be of worth further taking to the trial. Now let's talk about the subject of evidentiary value of FIR and statements made to the police officer, which is second part of the chapter 1. So this is evidentiary value of the statements, which is under section 180 and 181 of the BNSS. So let's read 180, 181 first. So we're taking example of a forged instruments under 180, 181, and we'll see what is the procedure. So any police officer making an investigation of the right rank, and if that person is doing such investigation, the person shall be bound to answer. The person in question is bound to answer truly all the questions relating to such case, and any questions to which would have a tendency to expose the charge or penalty for whatever the reason. And they have to reduce in writing any statement made to them in the court. So we spoke about those sections at the start of this session only. And no statement made by any person to police officer of investigation under this chapter shall, if reduced in writing, be signed by the. So if the whatever has been given to the police, somebody, any witness or anybody who is giving a statement to the police, it is in general not required to be signed. And the people are designated differently depending upon their roles in the investigation. So it might be a complainant, it might be a victim, it might be an accused, and then a witness also, which by name itself reveal that it is an individual who knows as a first-hand knowledge of the occurrence of the criminal case or the testifying any evidence. So seeing all those things in place, the evidentiary value of an FIR is always questioned in detail. So there are various case laws which talks about the evidentiary value of FIR. In principle, any statement which is given to a police officer is not considered a piece of evidence. The reason being probably uh, it might be sought, it might be recorded with a coercive method of the police officer. It might be of some or other kind of tactics which police might have used, and the certain statements have been recorded. Now, in case of FIR, it has a dual value. One, FIR is a first information report. So it is just a first set of clear information which is brought into first hand to set the law in the motion. So Supreme Court has multiple times has also said that in case of FIR, it cannot be one side, cannot be or should not be expected to be a Bible where everything would have been added at the very first place, because it is the first set of information that comes to the mind of the victim or the complainant, which is recorded at that point of time just to set the law in motion. While on the second side, the Supreme Court again also says that the evidentiary value of FIR is also limited to the particular persons giving information, but it doesn't really means exactly under what intention and what purpose the person might have recorded the FIR. So the FIR's evidentiary value, it has to be considered always been in support of the justice which has to be delivered and how it has to be done. So in case if I see the first dimension where the person might not have given the minute by minute, second by second value of the information in the FIR, it does not mean the value of the FIR is very less. In that case, if tomorrow somebody comes back and talks about a rape victim's FIR, and the rape victim who was in a trauma at that point of time when the FIR is definitely registered, the person has a first-hand experience of the crime happened to herself, and she's in a mental situation of dilemma, pain, agony, anger, etc. So it cannot be expected that the lady must remember the names of everyone. The lady must remember each and every sequence of action. What exactly has to come is the lady should be able to depict in what scenarios she was she got into that situation, in what situation she was hauled into that situation by the culprits, in what situations and how many number of people have roughly what they have committed and did they violate it and then how. It cannot be an expectation to expose a victim using an FIR by going back into the word by word wordings of the FIR and coming back and saying it does not hold an evidence. It is a very strong evidence that the victim might be lying. So in that case, the FIR comes for the rescue in terms of evidentiary value that yes, it can it cannot be something which can be considered to the teeth and evidence. It can only be given indication. So it saves the matter for the victim or the complainant that side. While the other side, it also says to be very careful that it's just a first information report and it is not known, it is not unknown that for malicious intents, people go ahead and file a complaint against each other. So there is a balance which is required to be kept in terms of the evidentiary value of the FIR, and that is something which is validated by various sections and of the BNSS and the Evidence Act. So with this overview, we'll deal with this section in detail at the end of the chapter because there are some sections we are now also going to read under chapter 3, which will have some discussions around this. So once you go through 179 to 193 with me today on chapter 3, then only it's better to go ahead and get into the section-wise understanding because it's a blend of BNSS and the Evidence Act, which is the new law, the Sakshya Adhiniyam, Bharatiya Sakshya Adhiniyam. Okay, so we'll do the combination after we read chapter 3 and we'll try to understand because certain part of it is covered between these sections also. So let me quickly go get into chapter number 3 first. Then we'll again come back to the evidentiary value of FIR and statements made to a police officer part in detail. So it is in general what we said is this is how the balance has to be done and which is recorded by various sections in Evidence Act and BNSS also. And even the statement made to a police officer is in general not considered in the court to be of any value, but then it is not always the case. There are exceptions also. So let's start chapter 3 first, which is talking about interrogation powers of the police officer, sections 179 to sections 193. So the plain reading of the section says any police officer making an investigation. The first section is 179 with the title is Police Officer's Power to Require Attendance of Witness. So any officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within the limits of his own or any adjoining station who, from the information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or above the age of 60 years, or a woman or a mentally or physically disabled person or a person with acute illness shall be required to attend at the place other than the place in which such person resides, provided further that if such person is willing to attend at the police station, such person may be permitted to do so. The state government may, by rule made in his behalf, this behalf, provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. So what does this section says is there is an authority to summon the witness. So when we talk about in this chapter, the in interrogation powers of the police officer, in that case, the very first topic which comes is police officer's power to require attendance of a witness. They can summon somebody. So it grants a police officer involved in the investigation authority to request the attendance of the individuals who maybe have knowledge about the facts and circumstances of the case. This is a very crucial for gathering evidence, of course, until and unless they are not available, it's very difficult for the police to investigate. So this is a crucial for gathering evidence. Now, scope of attendance required is also very clearly given in the specific cases that uh, the officer can require the attendance of any person located within their jurisdiction or in adjoining areas also through a written order. So it's not only the jurisdiction where the police station is, they can ask people from other adjoining areas also to come and make themselves present. So what is the obligation to attend? The individual who receives such order are legally then obligated to appear as requested, ensuring that the law enforcement can collect crucial testimonies from them. So police officer doing this investigation may by order in writing do this. So what is the other way the person can do it? If not by order in writing, so they may also, if the person is available, they can also verbally tell him and then reduce it to the writing and take a receival from the person. Protection for a certain individual is given, which is the males under age of 15 and over 60. So these people are one of the exception set. Second set of exception is women, mentally or physically disabled people, and those suffering from acute illnesses. So these people have to be talked upon at the place of their stay, where they stay. And in case of these people who are part of the exception also, if they want to still come to the police station, there is no bar, they can come. Then a payment of an expense is a provision given that they can empower to create rules that can mandate police officers to cover reasonable expenses. Again, reasonable word, keep in mind, by the individuals attending the court or police stations under subsection 1. So this is basically for the witnesses or people who has the first-hand information of the situation. And this has to be a fair compensation. So whatever is a fair travel possibility for their time and travel, that compensation has to be given to. Why this is done? This is to encourage. So this is a witness encouragement plan which is added so that the witness will come and cooperate. What is the role of a witness? A witness is somebody who gives a first-hand information about certain aspects or the whole aspect of the crime which has happened. But is there anything which is a benefit to the witness? I mean, it might be in some cases, but then mostly they have no benefits. So in that case, it is very much important that the witness still cooperate in spite of sacrificing their time and coming ahead and speaking about the crime. So to encourage the witness, it is very important that they cooperate with the law enforcement, and for that, the hindrance of a financial burden is taken away from this section. So it's a very strong section which talks about the investigation process, balancing a legal authority and personal right of the people, while also giving such exceptions and providing such kind of benefits to the people who are the witnesses. So this was section 179, the very first one. Now let's talk about under interrogative power of the police, examination of witness by the police. So how the witnesses could be examined by the police, there is a procedure. So subsection 1 says, any police officer making an investigation under this chapter. So this chapter is what? This is interrogatory power of the police officer. So any police officer making an investigation under this chapter, or any police officer not below such rank as the state government may by general or special order prescribed in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. So very first thing is the any police officer making investigation or any police officer not below rank who is examining who can examine orally any person uh, supposed to be acquainted with the facts and circumstances of the case. So, who is the acquainted with the facts and circumstances of the case? The witness. So, it says any police officer who can investigate. It talks about the right rank, and then it says or any other police officer acting on request of the police officer, the other officer. We have studied about this in the previous sessions about how a other police officer, on request of the other police officer, can execute the warrant or certain activities, inclusive of examination of witness. In practical circumstances, normally it is done with the permission of the police station in charge. So now we are saying is the any person, police officer who is investigating officer, or on his request, any other police officer of the right rank can orally examine anybody who is a witness. Point subsection 2 says, such person shall be bound to answer. Such person shall be bound to answer truly all questions relating to such cases put to him by such officer, other than questions the answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. So the witness protection we talked about earlier section was to help them cooperate, to help them come ahead for the cause of that particular crime to which they have become a witness, and to even up to the extent of going ahead and compensating them. So in this section, again, there is a protection which is given to the witness that the person shall be bound to answer all the questions relating to the case put to him. So in that case where he is talking as a witness, he can go ahead and answer all questions truly, and he is bound to do that. But he cannot be asked such questions which is exposing him to some other criminal charge or penalty or forfeiture. So by this, if you see, the law is very, very focused in this particular section, subsection 2, on exactly to the subject of that particular case matter. So if a trial is going on, it's an established way of legal practice, of legal trial also, that in one case, subject of one case cannot be called out in the subject of other case, other in case, and until the cases are not clubbed together. So if there are two separate cases, you cannot bring this evidence from this one to this one and try to prove something here if this is not connected. So that is why in to on the same lines of uh, the trial, the same way the procedure is followed, the person is bound to answer. Definitely he or she is bound to answer if a question which is purely relating to the case, and it does not mean that the person is bound to answer always in affirmation. They can answer in negative also. If they don't know something, they can say no. So when they are bound to answer, it does not mean they have to always say what exactly has been asked to say. Bound to say means clearly they are bound to respond. What they respond? Of course, they are liable if they go ahead and make a wrong statement, especially if they do it in an affidavit, but they are only bound to respond. And in such case, they cannot be asked to answer such question which is incriminating themselves, because incrimination of self is not allowed in the crime, in the law. Subsection 3 says, the police officer may reduce into writing any statement made to him in the course of an examination. What is happening right now? Until now, what we have discussed in section is examination. So under this section, and if does so, he shall make a separate and true record of the statement of each such person whose statement he records, provided that the statement made under this subsection may also be recorded by audio visual. It says may also be recorded. It doesn't say shall be. It may be. Provided further that the statement of a woman against whom an offense under section sexual offenses or grievous attack, etc., happens is alleged to have been committed or attempted in such crime shall be recorded by a woman police officer or any woman officer. So it always adds at the tail the special case of a women who are abused sexually or physically grievously. So what the sections 1, 2, 3 together if we read says, orally examination can happen of any witness through the IO, investigating officer, or any officer requested by him. And these people who are called the witnesses whose examination is happening are bound to answer truly all the questions relating to the case without incriminating themselves. And then the officer has to reduce whatever statement has been made in this examination, and he shall make a separate and true copy of the statement of each people whose statement he has recorded. And he might want, or she might want, the police officer can also record it also on the audiovisual devices, including a mobile phone. But in case of all those things, what is happening in section 180, if this is related to so and so sections which is mentioned here, which is a crime against a woman, it has to be strictly done by the police officer or a women police officer. So shall be recorded by a women police officer or or any women officer. So it could be a women police officer or any women officer. It could be anybody who is on the government's role. So recorded here should not be interpreted as video recording. It means recorded on paper or if required on the audiovisual unit. So what the section 180 says then? It says the authority to examine a witness. So police's authority is there to examine any witness, and to conduct the investigation further, they need to examine individuals who might have knowledge to that particular case, which are called who are called as a witness, and this includes officer at or above a specified rank. So of course the examination can happen, but only for the rank which is specified by the state government for that particular kind of crime or type of crime or specific crime, and which promotes a hierarchical and organized approach to investigate procedure. And there is a possibility of requesting the assistance of some other police officer in case maybe same rank, junior rank, within the rank limit for the investigation, or a higher ranking official. Obligation to answer is also second point, which is given by the very first few words of the subsection 2. So the person, the witness is has an obligation to answer. But it also talks about the obligation to answer does not mean obligation to be a parrot of the police officer. The words cannot be put in his or mouth and then they are obliged to say yes every time or commit or consider anything which that has been pushed into their mouth. No, they have to answer truly. And if this is done on oath, in that case, they are obliged, they have an obligation to respond truly. The limitations of the questions is also called, in spite of obligation to answer, they are not obliged to answer on anything which might penalize them for cause any forfeiture or cause any kind of punishment to them in case of protecting the right of the self-incrimination. So there is a protection of person's right against self-incrimination in the law that is followed for the sake of, again, safety and ensuring the presence of the witness and witness cooperation. The subsection 3 of the same section 180 talks about the documentation of the statement. Then finally, you are who are authorized by the rank and by the different authorities to be somebody asking a question to the witness. You have done the cross questioning, sorry, you have done the examination, and then you have to record the statements. So you have to make a either written record of the same, or you have to make an audio video recording of the same, or you have to make both together. So normally, even if you have a recorded by the audio video recording, you have to bring in a transcript. So either written record or audio video recording, which is done. Special considerations for women is only added to ensure whatever is happening through the police officers to the witness, that has to be always a woman to woman in case there is a woman who is involved. So this is section 180. Coming to the section number 181 for interrogation power of the police officers. So now this is what I was mentioning earlier. So there are certain sections which are covered for the evidentiary value of FIR and statement made to the police officer. So we'll cover some here. Then at the end, I'll bring you the overall picture drawn on the subject of evidentiary value of FIR. So section 181 talks about statements to police and its use thereof. So there are certain rules around that. Subsection 1 says, no statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it. So, any statement during the investigation, you go ahead and you speak with the police officer who is doing the investigation. You are the witness, probably, or you are somebody uh, who are being questioned by the police in the connection of that particular matter. And if they reduce the same, they're doing an oral examination of yourself, and if they reduce it in writing, no need to sign that particular, you're not bound to sign that particular statement. Nor shall any such statement or any record thereof, whether in a police diary or otherwise, or any part of such statement or record be used for any purpose, save as hereinafter provided at any inquiry or trial in respect of any offence under investigation at a time when such statement was made. So it cannot be used for anything else. Provided that when any witness is called for the prosecution, in such inquiry or trial whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in manner provided by section 148 of the Bharatiya Sakshya Adhiniyam. And that is why I said there is a mix of Adhiniyam also. And when any part of such statement is so used, any part thereof may also be used in the re-examination of such witness, but for the purpose only for explaining any matter referred to in his cross-examination. Nothing in this section, subsection 2 says, shall be deemed to apply to any statement falling within the provisions of clause A of section 26 of Bharatiya Sakshya Adhiniyam, or to effect to the provisions of the provision of subsection 2 of the subsection 23 of the Adhiniyam. Any omission to state a fact or circumstances in the statement referred in the subsection 1, which is, if made, may amount to contradiction if the same appears to be significant and otherwise relevant, having regard to the context in which such omission occurs, and whether any omission amounts to a contradiction in the particular context, shall be question of fact. So this is something which is talking about the uh, statements which are made to the police and how it can be used thereof. So it first says that no statement which is made to the police officer needs to be signed. If you bring in giving any getting examined by the police, which is reduced, so that has to be not needed to be signed. While that when a witness is called for the prosecution, so a witness from the side of the victim, in such inquiry or trial whose statement has been reduced in writing. So their statement has been reduced in writing, and aforesaid, any part of his statement, if duly proved, so whatever the statement they have made is proved also, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in manner provided by section 148, which says a cross-examination as to previous statement in writing. So a witness may be cross-examined as to previous statement what they have made by him in writing or reduced into the writing and relevant to matters in questions only, and without such writing being shown to him. So those things are not written and then not shown to him or being proved. But if it is intended to contradict him by writing, if it is contradicted, his attention must before the writing can be proved. So be called to those part of it which are to be used for the purpose of contradicting him. So if something is written, cross-examine, a witness is cross-examined to the previous statement, what he has made in writing or reduced in the writing. They might have given a statement, affidavit of the evidence, or they might have given an oral presentation in the court and which has been reduced to writing. Any relevant to matter which is in question without any such writing being shown to him. So they have talked about it earlier. It is not shown to them now or being proved. Nothing is being proved also at that point of time. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it. So then when you are contradicting that particular person, because it says if the person is contradicted, it might be used by the accused. But if the person has made some statement earlier, it's a cases run for a very long time. The person might have lost a memory of that also. In that case, if the person has to be proved wrong against something which the person asserted on writing or on verbally earlier, the witness, the duties of the party to ensure first his attention or her attention has to be brought on what point they are going to contradict him or her. So that is what this part of the section says. Then nothing in this section shall be deemed to apply to the statement falling within the provisions of section 23 and 26. So what is section 23? That no confession made to a police officer shall be proved as against a person accused of any offense. So this is one thing. Then section 26, what it says is cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. So it says an omission to the state. Nothing in this section shall be deemed to apply to any statement falling within the provisions of clause A of section 26 or subsection 2 of section 23. Okay. And 26A is nothing but when the person is talking about the cause of his death, when it is relevant. So what does section 181 says? It's a combination of Evidence Act and the BNSS, where it talks about the statement has to be police in general. What you do is has not to be signed. And in case somebody is contradicted or somebody is proved wrong, the person has to be shown that piece of paper or has to be reminded of it. And then during cross-examination, the person might be proved wrong. But it is something which is nothing in this section shall be deemed to apply to the statement which are falling in the section 26 where the person is already dead, or section 23, it is where the confession is made in front of the police. There is no application of this. It is not valid. So in the 26, it is not valid to be contradicted if it is proved by the relevant facts. And 23, it cannot be considered also a confession to be appropriate. So rules for the statement made to the police is given in 181, and it clears regulations around that. For example, there is no signature required. Any statement made to the police officer during investigation, no signatures are required. No, you did not fix a signature on that because it is not required. Limited use in proceedings. So the statement, record, whatever the in the police diary format cannot be used as evidence. So these things cannot be used in evidence in any subsequent inquiry or trial, which is regarding the offense being investigated at the time the statement was made. So it cannot be used as evidence in any subsequent inquiry also. So this limitation protects the against the use of potentially unreliable statement that were made in a non-adversarial context, ensuring fairness in legal proceedings. So if there is some statement which was made during this inquiry, cannot be used in the next inquiry. They have to again go fresh. So exception for contradiction in trial, subsection 1 says that the only exception for the prohibition on using police statement arises when a witness called for the prosecution has a statement reduced to writing. So that is the only exception to the prohibition of using police statement when a witness calls for a prosecution has a statement reduced in writing, because he is somebody in the party of the police. So in cross examination, in this case, the accused may use the part of the witness written statement to contradict the witness during the cross examination, but this is aligned with the principles of fair rights of trial because both the parties have rights to cross each other and ask questions, allowing the accused to challenge the evidence presented against them effectively. While if any part of the witness statement is used during cross examination, that same part can also be referred in a re-examination, but solely to clarify matters raising during cross-examination. It is only to expand the meaning of that. So this process will help to create a balanced opportunity for both the prosecution and defense to address inconsistencies of the issue. So in cross-examination, the other party goes ahead and cross-examine the person. They want to expose the person. They bring in the weakness of the witness, the false version, etc., etc. But in re-examination, what you do is basically you just go ahead and clarify the matters which were raised during the cross-examination. You are not directly going ahead and denying on that, but you re-emphasizes on certain part so that it it gives a balance opportunity that in spite of the person being hardly exposed by the other party, the defendants during the cross examination, for we're talking about the prosecution witness, the re-examination will again give a substance to his standing in that particular matter, which might be a little blurred because of the cross examination. Now, exclusion from these sections are also given, which is section 26 and A and subsection 2 of subsection 23, which is 26, as I said, is mention of confessions made by a person in custody, which may have different rules regarding admissibility and in use in court. And 23 is the legal protection specific statement remain affected by the section's provisions. So both are again protected. Section 26 A is when a statement is made by a person as to the cause of his death. So it is a statement which the person has given as a cause. It's a relevant statement. Then there is an omission which is explained under current section, and that is that the explanation clarifies that the failing to include relevant facts or circumstances which are failed to be included in the recorded statement. So if somebody has recorded a statement, the explanation which clarifies that the failing to include relevant facts or circumstances in the recorded statement can be constructed as a contradiction provided that such omissions are significant within the context. So it could be used as a contradiction to it if it is a significant within the context. If that particular facts are missed, for example, certain facts which are very much a key ingredient of that particular situation could be significantly contradicted. Determining whether an omission is substantial enough to qualify as contradiction is ultimately a question of fact that must be valid. So, for example, a famous case where a person was murdered in the backside of a hall. In the same hall at the start, one receptionist was standing. Now, the receptionist was somebody, a witness who was brought in, and he gave a statement about, he became a witness about the murder, saying that so and so person has killed so and so person, and the relevant facts, whatever he was supposed to give, was recorded when the witness examination happened, and this particular person failed to record in that particular his statement that what was the weapon he has seen that person killing the other person. Was it a knife? Was it a dagger? Was it a sword? Because that person had a weak eyesight. So in that case, this explanation which clarifies that failing to include relevant fact on a circumstance in the recorded statement can be considered contradictory. So this person, if the relevant fact of the weapon itself was not very clear, but the person was not even able to see a weapon in the hand, how would the witness could be considered relevant and not be contradicted to somebody who has really seen Mr. X killing Mr. Y? It could be Mr. Z killing by Mr. Y also. So practical implication is a protection of the accused right. So the accused's right is also something which is protected by section 181. It encourages an accurate reporting and prevention of a preservation of a judicial integrity is done. So it is a very important guideline. 181 is a guideline regarding statements made to the individuals, to the police officer, its evidentiary value, etc., etc. Coming to section 182, no inducement to be offered. So this goes further into the angle where inducement could be in question. So no police officer or other person in authority shall offer or make or cause to be offered or made. It is very cleverly written about the person in authority, no police officer or other person in authority. So the police officer or anybody who is in authority in that particular situation shall offer or make or cause. So shall offer themselves or make or let it happen or cause to be offered. So through somebody they can cause it to occur or made. Any such inducement, threat or promise as is mentioned in section 22 of the Bharatiya Sakshya Adhiniyam. So that cannot be done. And then but no police officer or other person shall prevent by any caution or otherwise any person from making in the course of an investigation under this chapter any statement which he may be disposed to make of his own free will, provided that nothing in this subsection shall affect the provisions of subsection 4 of section 183, which we'll talk shortly about. So this is something which talks about the no inducement to be offered. It says a police officer cannot do themselves, or anybody in authority cannot do themselves or cannot make it happen any such inducement, threat, or promise as mentioned in section 22 of the Bharatiya Sakshya Adhiniyam. Okay. So 22 says it is about a confession caused by inducement, threat, coercion, or promise where irrelevant in criminal, which is where irrelevant in criminal proceeding. So if it is done using those ways, a confession, that confession has no value. That's what it means. But no police officer or other person shall prevent by any caution or otherwise any person from making in course of investigation anything what they want to do from their own free will. So it talks about the both the aspect. You don't make the person by any kind of inducement to say something as an officer or as a person of authority you want the person to do by any means, or you will not even stop somebody if they want to make a statement. So both the things. So it's a prohibition on inducement. The police officers and other authorities may offer for any form of inducement, threat, or promise to individuals regarding their statement. So that is not something which is required. For example, today morning in one matter, one person who comes from Delhi, he came with 112 grams of gold and he went to a shop in Hadapsar and he was trying to sell that gold uh, to his regular customer, the jewelry shop. By the time police comes and arrests that person, now this person's version is he has brought in a receipt with him of the gold purchase with the military man from whom he has purchased, while the allegation on him is the same gold exactly is being stolen from the other military man's home by this military man, and this was sold to him. And so the person is accused of buying a stolen gold and was arrested. They ran into my office, and when they came to there, my team rushed there, and then in presence of the police, of the advocates, the police tried to slap the person multiple times to make him accept his crime. So this is police officer was warned immediately, and then he took a shelter to the corner because inducements are not allowed. The police is not allowed by such means of force, pressure, coercion, etc. to avoid a fair legal proceeding, in spite of a person, the Supreme Court says, in spite of a person being considered a repeated offender, then also his rights as given by the procedural law still upholds. He might be sent behind the bar, or he might be hanged, he might be thrown out of the city, whatever has to happen, but it has to happen with dignity and no such coercions can happen. So this aligns with the principle of a fair legal proceeding. So such kind of inducements are, and which is very common with any police in any part of the world. It gives a reference to the section 22 of Bharatiya Sakshya Adhiniyam, which is the reference to this specific section highlights that the acknowledgement of the danger of compromising witness integrity through inappropriate influence, ensuring the evidence gathered is truly voluntary and genuine. The police has to prove that. So it cannot happen that they can gather evidences by putting such inducement to the individuals. But then again, the other side, the very interestingly, the section says there is again a freedom to make statement which also not to be curbed or put off. So there is a prohibition that you don't force people while inducement, but then again it says do not restrict individuals also from making such statements freely during investigation. So the environment, what indirectly it says is the police officer should be very diligent on asking the right questions rather than using inducement or such other methods, but then should also be very open, and the investigation has to run in a way this is we are talking about the chapter over interrogation. So the interrogation should be in such a way that the person who wants to speak also is not so much worried or afraid that he or she is not able to make a statement which they want to make also. It doesn't matter what facts they try to bring in and what version they want to bring in, but a free will of the voluntary statement has to be respected, and they should not be restricted for any individual for making statements freely during the investigation. It has to be also recorded and reduced in writing. So they should be encouraged to speak also. So this is a very important part for allowing the individuals to express their account voluntarily as well, and not to pressurize up to the extent where it doesn't comes. And this relationship to other provision is also given in this particular section, where the subsection explicitly states that its provision does not override subsection 183 of this particular subsection 4 of this particular uh, BNSS Sanghita. So let's now move to section 183 and we'll examine 183.4 also, what was mentioned there about the confession. So section 183 now talks about the recording of confessions and statement. Now, how you are recording the confessions and statement. So any magistrate of the district in which the information about the commission of an offence has been registered may, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter or under any other law for the time being in force, or at any time afterwards but before the commencement of the inquiry or trial. So any magistrate of the district in which the information about the commission of the offence has been registered. So in that district only may, whether or not he has jurisdiction in the case. So even if the magistrate does not have jurisdiction in that case, record any confession, because what we are using is the power of the magistrate to be able to register confessions only we are talking about. We are not talking about the trial here. So a statement could be made to him in course of an investigation under this chapter or under any other law for the time being in force, or at any time afterwards, but before the commencement of the inquiry of trial. So anything before the inquiry of the trial. Similar thing we have seen earlier also, where a public officer, if makes a complaint, or a judicial officer which makes a complaint, which also could be uh, respected by the courts, they could be noticed by the court, the cognizance is taken, but there is a possibility of the public servant of taking the complaint back also, where the complaint could only be taken back at the stage where the trial has not or inquiry has not got commenced. In that case, it was not finished the trial. In this case, it is before the commencement of any inquiry trial. So if the trial or inquiry is started, then they cannot. Provided that any confession or statement made under this subsection may also be recorded by audio video electronic means in the presence of the advocate of the person accused of an offense. So that is where, when such a confession has to be recorded, and any confession or statement which has to be done, it has to be done in the presence of the advocate of the person accused of an offense. So the magistrate, when they're recording it under section 183, the advocate is also mandated now. Provided further that no confession shall be recorded by a police officer on whom any power of a magistrate has been conferred under any law for the time being in force. So it has to be purely a judicial magistrate. It cannot be a police officer for whom any power of a magistrate, maybe executive magistrate power, has been conferred upon. So it has to be purely, it says purely, it has to be a judicial magistrate, and it can only be recorded uh, in the due course of investigation in front of the advocate of the particular person who is considered the accused. Subsection 2 says the magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and that he does so, it may be used as evidence against him, and the magistrate shall not record any such confession unless, upon questioning the person making it, he has reason to believe that it is being made voluntarily, because no person is allowed to get out of not speak out of until they are speaking out of their free will. Now, if at any time, the subsection 3 says, before the confession is recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. So if does not says I want to I'll make a confession, you will not go ahead and detain that person in police custody. Any such confession, this is part 4 we mentioned in the previous one. If you remember the previous section, the 183, 4 was mentioned there where it says that the wording clearly says any omission. Sorry, I moved to further. Yes. So the subsection explicitly states in the relationship to the uh, that provision do not override subsection 4 of the section 183. So the provision of no inducement to be offered we have studied in section 182, and that does not override the section 183(4), which is any such confession shall be recorded in the manner provided in section 316 for recording the examination of an accused person, and shall be signed by the person making the confession, and the magistrate shall make a memorandum at the foot of such record to the following. So they have to give a specially a note at the memorandum at the note at the footnote of that particular record that I have explained so and so person, he is not bound to make a confession, and that if he does so, any confession could be used against an evidence against him. And I believe that this confession was voluntarily made. It was taken in my presence and hearing and was read over to the person making it and admitted by him to be correct. It contains a full and true account of the statements made by him. Such kind of a memorandum has to be made. Subsection 5 says any statement other than a confession made under subsection 1 shall be recorded in such manner hereinafter provided for the recording of the evidence as is in the opinion of the magistrate best fitted to the circumstances of the case, and the magistrate shall have power to administer oath to the person whose statement is so recorded. So magistrate can provide has a power to administer oath. So they can ask get the oath by the person of the verifying the facts what he or she is writing, and then undersign that the oath has been taken in my presence, and that's what he can administer the oath. Subsection C has multiple parts. So subsection 6A says that in case punishable under section of sexual offences against women and the grievous injury, the magistrate shall record the statement of the person against whom such offence has been committed in the manner specified in subsection 5 as soon as the commission of the offence is brought to the notice to the police. So as soon as the offence is brought notice to the police, the magistrate should go ahead and take record the uh, evidence which is as per fitted as per the situation, and they have power to administer oath into that statement, provided that such statement shall, as far as practicable, be recorded by a woman magistrate, and in her absence by a male magistrate also in the presence of a woman. So if you don't have a women magistrate, you bring in a male magistrate, but then you bring a woman also together with the male magistrate. Provided further in case relating to offence punishable with imprisonment for 10 years or more, or with imprisonment for life, or with death, the magistrate shall record the statement of the witness brought before him by the police officer, and provided also that if the person making the statement is temporarily or permanently mentally or physically disabled, then the special educator assistance or interpreter assistance will be required. Provided also that if the person making the statement is temporarily, permanently, mentally, physically disabled, made by the person with the assistance of the special educator and the or the interpreter, and it has to be recorded in audio, video, electronic mode, preferably by mobile phones. Number B says a statement recorded under clause A of a person who is temporarily, permanently, mentally, physically disabled shall be considered a statement in lieu of examination in chief as specified in section 142 of Bharatiya Sakshya Adhiniyam, such that the maker of the statement can be cross-examined on such statement without the need for recording the same at the time of trial, which is nothing but the examination of witness. How the examination of witness happens, that is the procedure given in section 142 of Bharatiya Sakshya Adhiniyam, which says the examination of witness by a party who calls him shall be called his examination is chief. And the examination of a witness by adverse party is a cross-examination. And then examination of a witness subsequently to the cross-examination by the party is called as a re-examination. I've taken a session in your college also on the same topic. So you know that 142. So number 7, subsection 7 says the magistrate recording to a confession or statement under this section shall forward it to the magistrate by whom the case to be inquired or to be tried. So it's mostly then forwarded. So what is the detail in 183? It's about the authority to record statement and confession. Who is authorized? It empowers the any magistrate to record confession or statement related to offense during the investigation process. And it allows for clarity and accuracy. What has to be done while recording this? The timing has to be such that the authority, this magistrate has the authority to record the confession statement at any time prior to the commencement of the inquiry of the trial. Before the trial starts, this has to happen. Why so? Because this is an essential part which will go to the magistrate who is doing the trial. And this is something which might be very, very important even at the stage of charge, regardless of whether they have jurisdiction over the case. So magistrates are purely would be employed to out of jurisdiction also if the is a matter of a statement of record, and that is why this is not a matter of trial. It's a matter of recording a statement, and that is why they can do it out of jurisdiction also. This flexibility allow for a timely collection of critical evidence through any magistrate which is available. It says subsection 1 talk about the recording of the statement, which is statement and confessions can be recorded in writing if a police officer is conducting an investigation. They can also write and conduct while conducting an investigation, they can record in writing. They are prohibited from recording confessions, ensuring that any confession made is done without coercion and is an appropriate legal context. So that is why they are prohibited from recording confession. They can take statements, but confessions are prohibited by police, even if a confession made to the police has no evidentiary value. The provision allow that the statement also could be recorded through audio-video electronic means, enhancing the accuracy and reliability of the statements while ensuring the proper procedures are observed, especially when sensitive cases are involved. But still, it does not have a evidentiary value because on video also, be previous to video and after video or what is not in the sight of the video could be a coercive plan of action or a plan of design which could be executed by the police officers, and that's why the audio video recording can also be a sound statement made, a very accurate and reliable, but still cannot be considered foolproof. Point 4 says explanation to the individual making the confession. The subsection 2 talks about the explanation to the individual making the confession. So it is very, very important even for the magistrate when the confession is made that the person is completely aware that what are the rights they have. They have a right to not, they have a right not to respond also if they want, because they are not obliged to make a confession. This is ready for really for the sake of confession, and that any confession they make will be used against them in the court. They should know, so that they do not feel cheated tomorrow in the eyes of the law that they made a decision which is something which they were not aware of the consequences of. So this is a crucial for protecting the right of the people who are making the confession and keeping it voluntary. The magistrate must also assert whether the confession is made voluntarily during the questioning. So it's also a lock and key mechanism where, in spite of the person making a confession, agreeing to what the magistrate is saying and understanding that he understands or she understands, the magistrate also has to write that he has proposed that particular statement to the person making confession. The person has understood, and both has to sign and seal, so that basically this is purely recorded in the time into something which is made voluntarily. Withdrawal of a confession is also possible, which is mentioned in subsection 3, which says it had should an individual indicate that do not wish to make a confession, they can withdraw from this and before it is recorded. So they can withdraw from the confession. Withdrawal of confession is also possible. They can withdraw from that, because the moment I come back and say as a magistrate, there is something which could be used against you, you can come back and say, I don't want to make a confession. So you cannot authorize a detention If the person says, I don't want to make a confession, the person cannot be detained in the police custody. And this respect the individual's autonomy. Because if you do so, if there is a possibility given that way, it's an indirectly a coercive action against the person. Documentation of the confession. So confession recorded must adhere to the standards similar to those applied with the recording examination of an accused person. The recording must be signed by the confessing individual. And the memorandum is to be added at the end of the statement by the magistrate saying it was done voluntarily and I've explained everything. I've read even everything which is recorded, reduced on the paper. Statements recorded are according to statements are recorded accordingly to subsection 5. So any statement made not classified as confession will be documented in a manner suitable to the circumstances of the case, which is a magistrate's discretion, and the power to administer oath is also given to the magistrate to ensure that is also available to the person making a statement immediately. There are special considerations for certain offenses. For example, subsection 6 talks about the section specified the offenses under sexual offenses or the offenses against grievous injuries to the women. The statement of the victim must be recorded by a female magistrate, or if not possible, a male magistrate accompanied by a female. So that is also something which is given as an ingredient under this section 183.